Welcome. My name is Professor Mark Anthony Neal. I am Chair of the Department of African and African American Studies here at Duke. I will be your moderator this evening for this conversation about civil rights and voting rights here in the state of North Carolina in advance of the hearing tomorrow morning in Raleigh. I'd like to acknowledge the Duke Council on Race and Ethnicity, which is the Duke-based co-sponsor, as well as the Raben Group, which is our sponsor from up in DC. Very briefly, we will have comments and discussion among the panelists, and then we will segue into a Q&A period. And I'll take a moment now to introduce the panelists. Debo Adegbile is a commissioner at the U.S. Commission on Civil Rights. He's also a partner at Wilmer, Cutler, Pickering, Hale, and Dorr, a position he's held since 2014. Previously, from 2013 to 2014, Mr. Adegbile was senior counsel to the chairman of the United States Senate Judiciary Committee. Prior to the Senate Judiciary Committee, for over a decade, he held a number of leadership roles in the NAACP Legal Defense and Educational Fund, including acting president and director of litigation. During his time at LDF, Mr. Adegbile argued two of the most significant civil rights cases in decades before the U.S. Supreme Court: Northwest Austin Municipal Utility District Number 1 versus Holder and Shelby County versus Holder. Both cases involve constitutional challenges to the core provisions of the Voting Rights Act of 1965. Juliana Cabrales is Mid-Atlantic Director of Civic Engagement with the National Association of Latina and Latino Elected Appointed Officials and Educational Fund. In this capacity, Juliana promotes the organization's civic engagement campaigns in the Mid-Atlantic region and North Carolina while providing programmatic support to national civic engagement efforts. Prior to joining NALEO, the Educational Fund, Juliana served as Latino Outreach Coordinator with the North Carolina Victim Assistance Network. Richard Enstrom is a leading expert on redistricting and a faculty associate in the SSRI, the Social Science Research Institute at Duke. Dr. Enstrom retired from the University of New Orleans, where he was a professor of political science and Africana studies. He was a consultant with the Center for Civil Rights at the University of North Carolina Law in 2006 to 2007. He served 2 terms as the chair of the Representation and Electoral Systems section of the American Political Science Association. Dr. Enstrom is a frequent expert witness in redistricting cases throughout the U.S. Kerry Haynie is co-director of the Duke Council on Race and Ethnicity. He's a faculty in the Political Science and African American Studies departments and directs Duke's Center for the Study of Race, Ethnicity, and Gender in the Social Sciences. Haynie's research specialization includes race and ethnic politics, legislative processes, state politics, Southern politics, and comparative urban politics. He is co-editor of the volume, New Race Politics in America, Understanding Minority and Immigrant Voting. Catherine Lhamon is chair of the U.S. Commission on Civil Rights. President Obama appointed Lhamon to a 6-year term on the commission on December 15, 2016, and the commission unanimously confirmed the president's designation of Lhamon to chair the commission on December 28, 2016. Lhamon also litigates civil rights cases at the National Center for Youth Law, where she has been of counsel since October 2017. Before coming to the commission, Lhamon served as the Assistant Secretary for Civil Rights at the U.S. Department of Education. Immediately prior to joining the Department of Education, Lhamon was Director of Impact Litigation at Public Counsel, the nation's largest pro bono law firm. Before that, she practiced for a decade at the ACLU of Southern California, ultimately as Assistant Legal Director. Theodore is the Julius L. Chambers Distinguished Professor of Law and the Director of the Center for Civil Rights at the University of North Carolina School of Law at Chapel Hill. Professor Shaw was the 5th Director Counsel and the President of the NAACP Legal Defense Fund and Educational Fund, for which he worked in various capacities over the span of 26 years. He has litigated education and employment, voting rights, housing, police misconduct, capital punishment, and other civil rights cases in trial and appellate courts and in the United States Supreme Court. In addition, Professor Shaw has testified on numerous occasions before Congress and before state and local legislatures. I think before we begin, I would ask Catherine to talk a little bit about the work of the commission,
Sure.
particularly as a lead up to this conversation tomorrow.
Sure. Thank you. Thanks very much, and thanks to all for coming. I really want to thank Kerry and DCORE and the Raben Group for bringing us together for this conversation, and I thank all of you for your intense interest in voting rights. The topic is so critical to democracy and critical to civil rights. The Commission, the U.S. Commission on Civil Rights, has written now 20 reports in our 60-year history on this topic alone, and we have issued that number of reports because of the volume of concern that continues in the country over the contest for civil rights, and also because of the core component of democracy and civil rights that voting rights is and has to continue to be. So we are really thrilled to be with you here and hope that we will be with you tomorrow also at the Raleigh Marriott Crabtree to participate in the all-day briefing that we have planned on voting rights. I want to say that in addition to my fellow Commissioner Debo on my left, we also have the Vice Chair of the U.S. Commission on Civil Rights, Patricia Timmins Goodson, and another fellow Commissioner, Kerry here in the room with us. So we have a strong showing in our commitment to this conversation here and around the country. The reality for us is that when we are talking about voting rights, we're not talking only about the mechanics of have you voted or have you not. We are talking about who counts as a person for our democracy and whom we will participate with in democracy. And so it's a really critical question for all of us, and when we over time denigrate that right to vote, we constrict that right to vote, we are taking actions that harm the fabric of who we are. The 20 reports that the Commission has reviewed and issued in the 60-year history of the Commission have looked at a variety of topics that include efficacy of federal civil rights enforcement, language access, whether there are people who are intimidated in trying to exercise their right to vote, and whether there are actual impediments to being able to exercise that right. Those are the same questions that we will hear expert views about tomorrow, and that we will continue to analyze and opine on at the end of our briefing. I want to say that it's the charge of the U.S. Commission on Civil Rights, and has been the charge for the Commission, to be the nation's eyes and ears with respect to civil rights. And so it's important to us to be able to hear in conversations like we're having today, and conversations like we will have tomorrow, from experts and from non-experts, ordinary citizens, about their experience of the right to vote and of trying to exercise the right to vote. It's very, very important to us to hear from you. There is a 2-hour open comment period at the end of the day tomorrow from 6 to 8, which is dedicated to that project, and we would welcome hearing from you all there. In addition, the Commission will keep open our record until the middle of March to be able to hear written submission about voting rights as well. And so we would really welcome yours and your friends and peers' views about voting rights in addition to the conversation that we're having today. Because the Commission itself hasn't heard the testimony that we'll hear tomorrow, I want to turn to what our state advisory committees have told us about voting rights in recent years. We have a state advisory committee in every state and also in the District of Columbia, and several of them have taken up the issue of voting rights. Most recently, we've heard from Illinois and from California and from Kansas about voting rights, and then we have multiple states that are in process of working on it as well. The Illinois, Kansas, California reports that we've received tell devastating stories of people who are unable to vote. For example, in Kansas, people who try to vote presenting a native ID, which is permissible in the state to use as identification for voting, but were turned away because poll workers did not believe that that was a sufficient identification, and so were unable to vote. We heard from people in California that they were physically unable to access the polls because their disabilities were not accommodated at the polls, and so that we had polling places that people could not get to and were not able to exercise their right to vote. In Illinois, they examined a 14-year period from 2000 to 2014 and found 0 instance of voter fraud in the state, which is good news. But they did find that there were police officers, sheriffs intimidating people. The county poll workers testified to our state advisory committee that there were police officers standing with guns visible intimidating people from being able to exercise the right to vote in recent elections in the state of Illinois. The kinds of challenges that I'm describing are not challenges from our distant past. They're challenges that we're hearing about from states right now, about people who are unable to live the basic promise that each of us has the sacred right to vote. So those are the kinds of concerns that we are hearing from our states. I look forward to hearing what we will hear tomorrow, and I would welcome hearing more from all of you. I just really want to be very clear before I turn to my fellow commissioner that the bipartisan, by statute, U.S. Commission on Civil Rights is interested in hearing your views and being able to collect our expertise and apply it to what those views are to be able to safeguard this right. I'll pause. So thank you.
Thank you, Catherine, for those important remarks. Unlike the chair, I'm not speaking officially for the commission. I'm speaking as an individual in my own personal capacity, but I'm an individual who cares a great deal about this topic and has spent some time litigating cases and working on policy issues in the voting rights space. I'll add one addendum, which is that our vice chair, Patricia Timmins Goodson, is North Carolina's own Patricia Timmins Goodson, so it's very nice to be in her home state for this briefing. And I will begin by going backwards and talk a little bit about why we are doing a field briefing here in North Carolina, why the Civil Rights Commission is here from my perspective, and then back into some of the history, because one of the important things about the Voting Rights Act is that it is a story of American history, and it has continuity. And so thinking about the issues we face today have deep roots in our history, and for that reason, it's important to both consider the present manifestations and from where we've come. So on that point of why we're in North Carolina, the Voting Rights Act has protected the nation, and there have also been provisions that have been hotly contested in litigation over many years that have protected some of the states and local jurisdictions that had some of the deepest histories of racial discrimination. The Supreme Court in that Shelby County case determined that some of those protections of some of the special provisions of the Voting Rights Act, the preclearance provision, were struck down and in effect neutered by the Supreme Court in the Shelby County decision. And what that meant is that some states, like North Carolina, that had been covered by these protections, and what that means in English is that certain jurisdictions that had demonstrated histories of racial discrimination in voting had to have voting changes presented to the federal government, either to a court or to the Department of Justice, to be pre-approved before they could take effect. The reason that that system was in place is because there had been such a pattern of trying to follow up discriminatory changes and court rulings, dislodging them with a new practice. As one Supreme Court justice called it, it was the practice of pouring old poison into new bottles. And Section 5, the preclearance provision, was designed to disrupt that pattern. It was designed to give the presumption of being able to vote to the people and to take away the backroom deals and all of the types of intentional and or result-oriented discrimination that for so long had taken effect in many parts of the country. The Supreme Court struck that preclearance provision down, and what it did is it changed the way in which state and local officials in some jurisdictions could think about putting forward new voting laws. Under the old regime, until the voting measure was approved, it could not go into effect. It had no legal effect. And so there was an incentive not to discriminate, because it was very likely that that discrimination would be rooted out, cast aside, and you'd have to go back to the drawing board. What changed with Shelby County coming down is that legislatures were able to promulgate new voting laws, and then the burden was shifted to the citizens, to the voters, to try and dislodge a voting law, no matter how discriminatory it may have been in intent or effect. That's a substantial game change, and that's part of the story that has been playing out in courts, many different courts in North Carolina, with respect to legislation that was passed almost immediately after Shelby County was struck down. And so the roots of this story, of this history of voting discrimination and efforts to dislodge it in the court reach way back in North Carolina. I think if there are history buffs in the room, you may learn that there was a member of Congress Congress in the Reconstruction, who was the last African-American member of Congress, who gave a famous statement on the floor of Congress saying that while African-Americans were essentially leaving Congress at the end of his term, they would rise again like a phoenix. And there was, of course, a long period of no black representation in the United States Congress until the Voting Rights Act and the effects that it would have. So his prediction in North Carolina was prescient, and this story of the Voting Rights Act and the story that we're going to hear a bit about, hopefully in detail, on 4 panels with experts from a broad range of views tomorrow, all day tomorrow, is going to be a story that tells, in part, where we are in North Carolina and how we've come here, but also takes a broader national lens on these issues. Catherine said that the Voting Rights Act is in part about who counts in a democracy. And obviously, many of us like to think that everybody counts, but we're counted in different ways. And in our political process, voting really matters. Deciding who your leaders are matters. It matters at a school board, it matters at a county council, it matters in Congress, it matters in the presidency. And it's important to note that my late mentor, the late great Leon Higginbotham, who sat on the U.S. Civil Rights Commission years ago, and whom Ted Shaw and I knew and worked with on issues of voting, he was very fond of telling the story of Vernon Damer. Vernon Damer was an activist in Mississippi who owned a store. He was a person of some means in the Jim Crow South. Because he had a sort of a goods store, like a little market of sorts, and so everybody would come to the market. And he used his platform of the store to try and register people to vote. But his effort in doing so made him a target for the Klan. This is in the 1950s and before the passage of the Voting Rights Act. And ultimately, one day the Klan came to his house and set his house on fire. And Mr. Damer went to get his gun and return fire so that his family could escape out of the back door at the time that his house was set ablaze. And his family did escape. But Mr. Damer, who was trying to defend his home and his family, was very badly burned. And he later would die in the hospital. He had been targeted for his efforts to create a pathway for African Americans to vote. And Vernon Damer is said to have said in his hospital room, as he tried to convalesce, that if you don't vote, you don't count. And if you travel to Mississippi today and you were to seek out the grave site of Vernon Damer, those are the words that you will see on his gravestone. If you don't vote, you don't count. Tomorrow's exploration of voting is going to be asking those very important questions about how we are reconciling the 2 strands of American democracy. The one strand that says, have people come and decide who wants to lead them, and the other strand that says, we want to very jealously guard the franchise and treat it as a privilege and not as a right. This contestation is part of our history. It is the debate that we will hear tomorrow from experts from a range of views, and we're very grateful that you have come today to hear a little bit about this contested history. We hope to hear more about it tomorrow, both from the experts from around the country and North Carolina, and also from the public, who hopefully will come and sign up to offer their own views about their experiences here in North Carolina and perhaps elsewhere. The signups will be at 3 periods during the day. There'll be a 10:40 sign-up, a 12:20 sign-up, and a 2:50 p.m. sign-up. Don't ask me the rhyme or reason to these times, but it's like a voting puzzle. To look at the Voting Rights Act, you have to figure these things out. But come sign up, come share your ideas and your experiences about voting. And if you don't get that opportunity, the record will be open for 45 days after the conclusion of the briefing, and people can submit their views and their experiences with the Voting Rights Act to the Civil Rights Commission at votingrights@usccr.gov, and we welcome your input. Thanks so much for having us here. Thank you so much for teaching the nation about voting, and I will pass the mic to my good friends.
I have a question before we begin the discussion. So how is the commission, most of you were appointed in one administration, how is the commission being received in the current administration? And I asked that, been very mindful of, there was a commission last week that they all quit, saying they were not being received or paid attention to, so I'm wondering how your work is being received.
Madam Chair.
So I'm very confident that there is no one in the Trump administration who is ignoring any word that we write. But I will say that the charge of the commission is to be multi-partisan and to be independent, and to be able to provide advice and counsel to the President, to Congress, and to the American public about efficacy of civil rights policy and enforcement. The commission, each of the commissioners is appointed to a 6-year term, and they're staggered on purpose so that we will not align with necessarily the party in the administration. The commission has, in the year that Commissioner Adegbile and I have been on the commission, issued now 3 reports, and we have not heard lengthy response from the Trump administration to those 3 reports, and we have seen some steps taken that are inconsistent with our recommendations. For example, the first report that we issued in that time was a report about municipal fines and fees and the ways that some cities are preying on the lowest income persons and persons of color in their communities. And we encourage the Department of Justice to continue aggressive enforcement on that topic. We had received concern about that from conservatives and from progressives on that topic, and we made a recommendation to the administration to continue. We just in the last several weeks have seen this Attorney General, this Department of Justice withdraw guidance that the Department of Justice had issued on specifically that topic. So that's not the kind of enforcement that we had asked to see continued. I think it's still important to make the record for what is right. I think it's still important to speak for what policy should be. And I will say, in the 60 years of the life of the Commission has had to speak multiple times to particular issues at different points and has had success nonetheless. When the Commission was first created in 1957, its initial charge was to look at voting rights. It took until 1965 when we saw a Voting Rights Act passed. But the Commission was right along making the recommendations about what needed to be the law and what federal policy ought to be, and then we did see the creation of the most significant federal civil rights law ever passed. And so I believe that our time is coming in terms of the actual legislative response to our recommendations as well.
You know, it begs the question, though. We are really having the same kind of conversations now in 2018 that we might have been having in 1968. 50 years later, we're still grappling with the same kind of issues. On the one hand, for the panel, why do you think we're still in this place? And what then do you say to folks who will look at the landscape of the last 50 years and look at what the Congressional Black Caucus looks like, or the number of Black municipal mayors and Latino municipal mayors, or even look at the fact that there was an African American that was in the White House, for 8 years, that appointed the 2 of you as examples. What do you say to those folks who are like, well, there can't be a problem, right? Why are we so engaged in this process now when it seems as though we should be in another place now?
I'll just start by saying that query was essentially the central question in Shelby County, right? Because here was part of the Voting Rights Act, the historic Voting Rights Act. It is on any list of the most important enactments of Congress of any kind, not just civil rights laws, the most important enactments in congressional history. If you check, the Voting Rights Act is going to be there. And the fundamental question that the court was presented with in the Shelby County case, in my view, not the legal question, but the underlying question was, is this enough progress? How much progress is required before we take down this set of protections that have been in place and have been a driver of progress? And different views about what progress looks like and what progress requires is in part what was undergirding the fight in the Shelby County case. There are some who are prepared to declare victory. Here again, I would direct everybody to some historic cases. There were cases in the Reconstruction era. Right? In that period where the slaves had just been freed, people bearing the scars of bondage on their persons were walking among us, And the Supreme Court would issued an opinion that asked when will they cease to be, the freed African Americans, the special favorites of the laws, right? What's important about this history is to understand that in that time, when nobody could believe or seriously contend that the nation had done what it needed to do to bring equality to people who had been literally enslaved, there were already people that were impatient with the remedial measures that had been passed as a matter of constitutional amendment to bring greater equality to the country. And so my contention is that this tension of declaring the job done is with us from the very beginning. There's a certain impatience with the idea that we need to do more, or that we can move further, or that progress is an invitation to make more progress, not an effort to stand down and take away those things that have driven progress. This is a core theme, I feel, in American democracy, and it's why the fight for civil rights, and everybody to my left can speak to this at great length, as can the chair. It's why the fight for civil rights is an intergenerational effort. There is no generation that will be able to say we have arrived and we're done. It's a baton passing exercise where the next generation will always have to take up the baton and run their lap for justice and equality.
You know, when I teach my undergraduates about the Voting Rights Act, and I do start with the most important act ever passed by Congress. And in these days, I use as evidence for that is what's happening now, and what's brought us to this table now. Because shortly after 2008, I mean, all hell broke loose, and the attacks on voting rights were amplified and revved up. For example, I had my one class do a study to go look at voter ID laws. It's a class on state politics. Assigned them each a state and told them to go look and see when their state introduced voting ID laws in the legislature, who introduced it, what party, and come back. I knew what they would find. Right, so you saw a increased activity after the election of Barack Hussein Obama as president. So the success of the Voting Rights Act has brought us to this moment in some kind of way where people saw that success. You look at the Republican parties, what do they call it? The autopsy after they lost presidential elections twice. And they understood the demographic changes. And that autopsy made some sense, that they had to figure out ways to reach out to black and brown voters. But that's not what they done. They wrote the autopsy, considered it, and shelved it. And instead of reaching out, they gone on the warpath. Again, because of the success of the Voting Rights Act, I think we're at this moment. I think that needs to be recognized. It is a quandary as to been very successful, and at the same time, we're still here.
I think I would add from the Latino perspective, similarly, when we talk about restricting voting laws, this is intentional. This is an attempt to slow down the unstoppable, the inevitable. The American electorate is diverse. It's more Latino. It's more African American. It's more other groups, and they are trying to stop because we are making a difference. And I think, to your point, it's an intergenerational thing. I don't think we'll ever say we won, because there will always be new challenges. But when we get calls from Latino voters that tell us that their American-born spouse wasn't asked for an ID, but the Latina woman did get asked for an ID, that's what keeps us going, and that's what keeps telling us we need to continue this fight, because there'll always be attempts to stop us from participating and from voting.
Professor Shaw, you were one of the folks who argued for the continued support of Section 5 of the Voting Rights Act, which was, of course, knocked down in the Shelby County case. Would you be able to tell the audience what things you think you could have done differently or might have done differently, or was it just the political environment that we were in at that particular time that caused for Section 5 to be knocked down?
Well, first let me say to Professor Mark Anthony Neal, it's a privilege to be with him. I'm glad to be with you at any time. But secondly, let me take myself down a peg. I was not, in fact, one of the first to make those arguments, although I did make those arguments. And Debo Adegbile was actually also at the Legal Defense Fund when we were dealing with some of those issues some years ago. But even before that, someone I had over to dinner at my house 2-3 nights ago was one of the lawyers who took the lead on litigating many of these issues. That's Professor Lonnie Guinier.
She's in town.
Who also was at the Legal Defense Fund.
Lonnie's in town?
She was, indeed she was.
Head over the panel.
She was here. She was here. So I could show you on my iPad. She was here. You know, the scope of the Voting Rights Act, and when I think about the years in which it was enforced, when it was extended, I think about the 82 amendments to the Voting Rights Act, but even before that, you know, the broadening of the Voting Rights Act to address not only the issues of African Americans, but indeed, you know, the language provisions, et cetera. You know, this is one of the, as those of us who are civil rights lawyers have described it, it's one of the crown jewels, if not the crown jewel of civil rights legislation. But I also have to think about Julius Chambers, who played a key role not only here in North Carolina, but his effect was nationwide. And Julius argued some of the important voting rights cases that were decided in the 80s and 90s. And he brought many of the voting rights cases in North Carolina, the landmark cases during his time, in which he was one of the most important civil rights lawyers in the country. And I don't want to forget Julius. I have the honor of holding an endowed chair in his name, and it is a great honor, and I miss him terribly. But let me say a few more words, if I may, about this issue of what we did and why we did it, and what, as Professor Neal mentioned, what maybe we should have done differently, maybe we shouldn't. I think about this quite a bit because the phenomenon that the Voting Rights Act addressed included, among other things, racially polarized voting. What is racially polarized voting? I think probably everybody in this room knows what it is, but I use as an example, I remember, and when I say this in front of my students, their eyes kind of glaze over because for them this was Jurassic. But I remember when there was an election, a gubernatorial election in Louisiana. I think it was in 1991. Debo and Judge Higginbotham and I met not long after that. Actually, I knew Judge Higginbotham already, but he introduced us to Debo. In Louisiana in 1991, a candidate for governor was David Duke. I don't have to explain who he was. David Duke got the majority of white votes in Louisiana.
Twice.
Twice, yes. Well, thank you. Twice. He would left to white folks, with all due respect to not the folks who are kind of folks who are in this room, because you're self-selecting, but left to the white voters, majority of white voters, I should say, in Louisiana, he would have been elected governor of Louisiana. You all know who David Duke is. That's an example of racially polarized voting, where consistently, I mean, actually at that point, since Reconstruction, no black person had been elected to the state legislature. No black person had been elected to Congress in Louisiana. No black person had been elected to statewide office in Louisiana. When I say no black person had been elected to the state legislature, let me correct myself, from a majority white district as of that point. And as I said, left to the majority of white voters, David Duke would have been governor. That's racially polarized voting. And consistently, the representatives of choice, as the terminology goes, of black folks in Louisiana would not be and could not be elected. So that's part of what the Voting Rights Act was meant to address. Part of some of the case law of the Voting Rights Act, allowed us to address that issue where you had minority populations that were large enough, compact enough, geographically compact enough, politically cohesive enough, and where there's racially polarized voting. This is a case that Julius argued in the Supreme Court, Jingles versus Thornburg. Under those circumstances, you can intentionally draw majority-minority districts to counter that phenomenon of racially polarized voting. There came a point where that phenomenon kind of dropped out of the analyses. Certainly, it's not something that Chief Justice Roberts talked much about in Shelby County. But here's the thing. There was a point at which, and I was at the Justice Department under the Carter administration, yes, that's how old I am, and I was at Justice when Ronald Reagan was elected. And I was in the Civil Rights Division. And I'm not going to take the time to tell you about the conflicts we had with the people who were appointed by the Reagan administration to run the Civil Rights Division, but it was hot and heavy. What Republicans figured out around that time as they were stopping busing, they were stopping employment discrimination cases, particularly those that use the effects test, and going across the panoply of civil rights protections, basically eviscerating them. There was one area that where they enforced civil rights laws, and that was the Section 2 voting right provisions of the Voting Rights Act. Why? Because they figured out that they could use that to pack districts, to draw districts that were heavily black, and in fact more heavily black than they needed to be, thereby leaving adjacent and surrounding districts disproportionately white, and therefore districts that would elect Republicans. And that's what happened. North Carolina took that to another level. It's not only a matter of drawing districts that have been in many ways gerrymandered racially, but also they elected not only conservatives, but extremist conservatives. So that's where you ask the question whether we should have seen that on the horizon, whether we made a mistake. There were people who suggested that we were making a mistake in drawing majority-minority districts. I remember my response at the time was, why should it be that black folks are the ballast of the Democratic Party? Why should black folks, alone out of all the various communities, have to live with the fact that they would be unable to elect people from their community or even to elect white representatives if that was their choice, while other groups of people were not put in that same position. It made me think about Thurgood Marshall, who asked in the Brown arguments, he asked the Supreme Court, why of all the multitudinous groups of people in this country do you single out the Negro, in the language at the time, for this special treatment? So, that was my response. It's not that I always loved Democrats, but at the time, we wanted to be able to elect representatives of choice. The short of it is, I think we've come to a time, and it's a real dilemma, particularly in North Carolina, but in other places, where we have to ask ourselves, because I still think that what we did was right at the time, that we did it. And racially polarized voting is still a phenomenon. Make no mistake about it. Barack Obama's election was not the consequence of the majority of white voters in this country. So the point is that we still have this phenomenon of racially polarized voting, but we need to revisit the question of how these districts are drawn, because what we've been left with in many instances, and this is controversial, is African American representatives being the senior Democratic representatives in North Carolina and in other jurisdictions, including in Congress, in the House of Representatives, and at the same time being in a party that is in a political minority. And my view is, in spite of everything we fought for, we need to unpack some of these districts nowadays and address this issue of not only racialized polarized voting, but partisan polarized voting. So I know I sat for a while, but once I open my mouth, I can go for a while, so I apologize, but I want to put that on the table. And I know Dick he can say a lot about this issue that's more profound than anything I could say.
I want to shift just real quickly. I want to bring Ms. Cabrales into this conversation, along with the two commissioners who have to go to a meeting in Raleigh. The example that Ted just gave, of course, is one of a very distinct black-white racial history that we know, we understand, that we react to. Post-1965, of course, demographics are very different, and there's still some inability to understand what a Latina voter is. A Cuban-American voting in South Florida votes very different than a Puerto Rican or a Dominican in New York, votes very differently than a Mexican-American in Austin, votes very different than a Chicano in San Diego. How has the influx of Latino citizens and as voters changed the dynamics of this conversation?
Yeah, without a doubt, and I think post the Shelby decision, 1 out of every 4 Latino voters in this nation lost protections. So that's what it looks like. As we saw this influx of restrictive laws, here we saw it here in North Carolina. Remember staying up, listening to the state legislature up late at night, waiting for this to pass. That happened across the country. We did some analysis ahead of the 2016 election, and in Texas, which we know has had a huge growth in the Latino population. It's a state that is considered a red state, so there's some interesting dynamics locally. We looked at what the voter ID law that was implemented there, what impact that would have on Latinos that had already voted in the state, and it showed us that close to 750,000 Latinos might not have the ID necessary to vote, even though they had already voted. These weren't naturalized citizens, these weren't first-time voters. These are probably second, third, fourth generation Americans. And like you said, it shifts greatly. With the most recent counties designated under Section 203, we saw Gwinnett County in Atlanta pop up, right? It's one of the first counties in the Southeast, not counting Florida, which we know is a slightly different. And so I think we in our conversations with the State Board of Elections, in tomorrow's public commentary, we need to start looking at how can we make voting more accessible for Latinos? How do we get State Board of Elections to start producing materials in Spanish, even if it's not required under 203? We have an influx of Puerto Ricans post-Hurricane Maria, and we need to start that going in order to make sure that everyone's able to cast a ballot and that it's a fair process for everyone.
Commissioner Seven.
I will just say I would like to add to that. I'm delighted to hear that you're planning to come tomorrow, so thank you for that, and looking forward to hear what you have to say. The language access issues are so core to being able to participate in democracy and to be able to be part of the promise of the Voting Rights Act. And among the materials that we have received in anticipation of tomorrow include seriously presented arguments about how you're not really voting if you need language access materials. If you need to have the materials translated, then you're not really participating in democracy because you can't understand the rest of what is happening for you. That is not a view I share. That is a view that is presented to us. And as we think about what voting rights protection needs to mean and what it needs to mean for us to have a fully inclusive democracy, we need to think about the point that my fellow commissioner raised in the beginning about whether this is a right or whether this is a privilege, and whom we have access to for that purpose. So I will end there, and I apologize that we do have to go back for a meeting, but I don't know if you have any last parting thoughts.
I'm just glad to be here with you. Look forward to your testimony tomorrow, and thank you all for coming to hear about the importance of these issues.
Okay. Give him all the mic.
Ted talked about racially polarized voting. You would think if there was something that didn't need documentation, that everybody knows it, all you have to do is look at the precinct votes and who lives in the precincts. But it's become something now greatly contested again. I'm working on a case now in Gwinnett County, Georgia.
Lots happening down there.
Yeah. Oh. And I mean, basically all I'm testifying about is racially polarized voting. But I've had to write an initial report, a supplemental report, and I have to go back to the office tonight to write a rebuttal report, all involving racially polarized voting. You know, I used to tell my students, look, it's not rocket science, you know, but it's becoming that. The arguments and the fights we get into. And Ted mentioned partisan polarized voting. In Gwinnett County, and like so many of the cases I work with protected groups under the Voting Rights Act. But in those cases, it's so common for me to end up having to fight off a claim that what I find is not racially polarized voting, it's partisan polarized voting. Everything today is party, party, party. And if it's party, hey, you know, it's like political scientists who work the other side of cases don't understand. I mean, they want to deny that there's a race and party entanglement in this country. And it's like this expert I'm facing with and rebutting tonight, he's saying, no, you don't have proof of racially polarized voting, you have proof of partisan polarized voting. And you know, I felt a little awkward because I plan to talk tonight about partisan gerrymandering rather than racial gerrymandering per se, because I'm excited about what's going on in North Carolina and our federal courts. But even the partisan gerrymandering, it is not. I mean, Ted talked about ballast. Some people call the minorities filler people. You know, you put them in over there to fill out the one person, one vote. You put them in over here, so you pack more of those votes so that Republican districts will be more likely to elect white Republicans. It's getting incredible. And what we used to fight over methodology, then we had a long lull, thank goodness. A professor at Harvard developed a methodology that, you know, that was pretty well viewed as the best methodology, and experts on both sides were using it and that sort of thing. But we're back into that fight again. And and especially when we talk about partisan gerrymandering as well. There's an expression, or a quote I like to use quite a bit, which is gerrymandering is a lot like pornography. You know it when you see it, but it's awfully hard to define. Well, when you say it's awfully hard to define, what that ends up meaning is it's awfully hard to measure. You know, you see it something different, I see something different, that kind of thing. But, so we've gone through a lot of stuff now in partisan gerrymandering. It used to be that if you filed a partisan gerrymandering case, it didn't take too long. You get a short opinion saying, oh, there are no judicially manageable standards. Get out of my court. Things have changed, at least in North Carolina. This is the recent decision in Common Cause versus Rucho. All right? This is no slim opinion. This is all opinion. This isn't the evidence. This is a summary of the evidence. And it's gotten very, very sophisticated. But we have some wonderful news. This case is wonderful news. I don't know how long it's going to be wonderful news because it hasn't gone to the Supreme Court yet. But it's right now it's wonderful news. This concerns after having elections for 3 congressional elections in a row under a racially unconstitutional racial gerrymandering of our congressional districts. Finally, in 2006, the legislature was forced to stop that, to correct that, supposedly. But what did they do? They turned, as one of the legislators said, oh, we just turned our racial gerrymander into a partisan gerrymander. Consequences were the same. Republicans win 10 out of 13 districts. Even won that much without having a majority of the votes cast for congressional candidates. And it's like, wow. So this case involved probably the most incredible combination of qualitative and quantitative evidence. When I talk about the qualitative evidence, it's hard to even think of what went on as well. We have a state legislator in North Carolina, a Republican who has in charge of the House effort, and no doubt some of the Senate effort, at drawing congressional districting plans and state legislative plans. His name is David Lewis. He's a representative, a Republican representative. The man has more hubris than anybody I've known, I think, because he stands up there and he's the guy that said, no, we've changed the racial gerrymander to a partisan gerrymandering because partisan gerrymandering isn't illegal. Well, times may be changing. He also said, we drew a plan that would give us 10 Republican districts and 3 Democratic districts. I wanted to do 11 Republican districts, but I couldn't get that 11th one to work. All right, this is the man, he goes into court and he's telling federal judges that he believes they can't touch him because partisan gerrymandering there's no standard for it. So, but the qualitative evidence, it's like he admitted it. It was the intent was clear. It was like the old days when white politicians in the South used to say, darn right I did that to hurt the blacks. And they didn't say blacks, but it's almost like that's we're back into that kind of space. I'm going to do it, and I'm going to brag to my constituents about it. So I would have thought this guy standing up there, this is why we did it, this is how we did it, this is what we wanted. And voila, 2016 election, 10 Republicans are elected, 3 Democrats. It was just as they were predicting. But it doesn't stop there, all right? Because there's new methodologies being used. We can't just put a legislator up there and have him admit that, yeah, that was our intent, or brag about that was our intent. And so what happened in this case was people have been writing articles about this approach to proving gerrymandering, especially on the partisan side. But it finally got into a court case, and 2 people, a mathematician at Duke named Jonathan Mattingly, and a political scientist at Michigan called Joe Wei Chin. They both did they did variations of this approach, which is to have the computer draw lots of random districting plans. I don't mean 12, 15, 20. Mattingly drew 24,000 randomly drawn computer districting plans. You put constraints on what the computer can do, like population equality, compactness. You try to emulate the constraints the legislature claimed they were working under. But these 2 went into court, and they proved, that it was so unlikely, given the constraints the legislature claimed it worked under, to come out with a plan that resulted in 10 Republican congressmen and 3 Democratic congressmen. The probability, the statistical probability of that plan resulting was, I think in both studies, less than 1%. And then sometimes it was, I think it got decimal points too further out. It was incredible. And the court had said that in terms of Mattingly's testimony, strong evidence. And it said concerning Chin's testimony, compelling evidence. And what the court then did was rule that the combination of qualitative testimony and quantitative testimony was showing clearly the intent of the legislature was to discriminate against people that didn't vote for the Republican Party. So this is big news. Political scientists have gone through lots of efforts as to how to try to measure gerrymandering. It sounds like right now, I am so excited about this kind of work that, I have to talk about it a little. And then I have to warn you, this may be very temporary. These methods are more sophisticated than the methods that were used in the first partisan gerrymandering case. The court has accepted this go around, which is the case in Wisconsin involving state legislative districts. That case has been to a hearing in the U.S. Supreme Court. Now, its methods were nothing as sophisticated as these. But anybody know what John Roberts referred to those methods? It got a lot of attention. Sociological gobbledygook. Chief Justice of the Supreme Court trashing this kind of methodology, calling it, fortunately, sociology, not political science gobbledygook. But wow. And so I'm not terribly optimistic that when this case gets to the Supreme Court, and it likely will, I think right now it's stayed temporarily, something like that. But it'll probably get up there. And I don't have any confidence the court is going to respond to this kind of evidence, even the blatant admission of what the legislators did, they're not going to respond to that in a positive way. So I'll end soon, but this is, right now, I'm on a high. I mean, I like the work these people are doing, and this success is so wonderful. But we got another big hurdle to go over. We have a Chief Justice, almost, I mean, I probably shouldn't say it. He must be a Luddite or something. I mean, it's like, gobbledygook? What kind of legal expression is that?
Well, let me raise this question for the panel to think about. You had a generation or generations of young, enterprising legal minds that took advantage of the possibility of gerrymandering to allow for black representation. That possibility has in some way been taken away now. When we think about gerrymandering now, you know, one of the ways that gerrymandering is maintained is through housing discrimination, right? If you keep people from being able to move into other spaces, right? So those things go hand in hand. I say all of that to say that in a moment where we see the work of folks like Black Lives Matter or Latinx or a range of kind of social justice movements, how do we get young legal minds to be passionate about this work, to find those brilliant little moments that they can pull out of the laws to bring big data to bear in this conversation, which is exactly what the right is doing, so that it's not just about the protests in the streets, but folks actually actively engage in the changing of the law.
Mm-hmm. You bring up a very interesting point, because there's now an expression, and some of these people that work on computer-assisted random districting plans use it, and it's called natural gerrymandering. And all it refers to is basically the inner city, the older suburbs have concentrations of African Americans, and the further out suburbs have lots of white folks, right? And that's just natural. That's just natural. It's like these people don't realize how that residential segregation pattern developed. And what role the government played in creating that pattern. But it's no longer a government-induced kind of form. It's a natural thing. And natural gerrymanders, you can't do anything about natural gerrymanders. So you're right, we need some help.
Yeah, Mark, this is a good question. I mean, it's something that I'll put to Professor Shaw, who teaches in the law school. But as a social scientist, we see fewer and fewer people coming along interested in these kinds of issues. And in part, I think it is that we thought the battles were won. I mean, really, it is surprising to be thinking, here we are in 2018, fighting about, as you opened the conversation, that were fought, 40, 50, 60 years ago, that we thought we put that to rest, and now here we are again. I know one thing that Dick has worried about, as he is thinking about retiring, I heard him say earlier tonight, he's end of the year. There's not many more experts who can go into court and do what Dick does. Social scientists who come in and do the kind of analysis. And I know you and Anita Earls put together a training for young expert witnesses several years ago. But it is a big question that this generation that's going to retire and get out of the trenches and get some well-needed rest, what's the second wave, third wave?
Well, I had a reaction to the notion of getting a well-needed rest. And forgive me, Dick, for saying this, but you rest when you die. Anybody who thinks that these issues had been resolved and would not recur, or there wouldn't be a need for another generation to address them, was living on some other planet. There's nothing in our experience in this country, as Americans, as anyone, that tells us that these issues are not going to require another generation's attention. I mean, it's just simply not so. I'm not as despondent about another generation. I think there are people, plenty of people who are interested in this. This whole theory that's being used in Gill versus Whitford, the case is pending in the Supreme Court with respect to looking at votes and determining whether, in effect, they're wasted votes because the gerrymanders, the partisan gerrymanders have been so extreme that it doesn't make any difference whether somebody in an extreme gerrymandered district votes, because the outcome is already preordained by the way the districts have been drawn by legislators. But we didn't have the theory that's pending now. I'm not going to tell you, can't tell you it's not going, that it's going to win for sure, but it's more than what we've had before on partisan gerrymanders. We were dealing with the fact that, the Supreme Court had consistently said with respect to partisan gerrymanders, no, Jubilee and all these other cases, right? And, that you couldn't do anything with this. We're living in a time when there's so much extremism on the state level and on a national level that I hope that the one vote, because that's what I think this is about. Now, there's always a danger that the votes that we think about as being the most liberal on the Supreme Court, that we could lose somebody. There's always that danger. Somehow, we could lose one of those votes. But assuming that we hold them, this is all about the same justice that we've been thinking about in every civil rights case that has been going to the Supreme Court for a matter of decades now. And that's Kennedy. It's his vote. I mean, every vote counts, but some of those votes are already pretty much predetermined. I talk about predetermined votes, or the effect being predetermined. And so we're all thinking about Kennedy. And the question is whether he could, at this point in his career, because there's not a lot left ahead of him, he could at this point, because we know where Gorsuch is going to be, even though he hasn't passed on one of these cases before. Does anybody in this room have a doubt? I mean, I shouldn't be saying this as a, as a law professor and a lawyer, but why dance, around this? Does anybody have a doubt about where Gorsuch is going to be? Now, I would love to be surprised. I would like nothing more than to be proven wrong. It ain't going to happen. And so the question is, where Kennedy is going to be. Otherwise, because Gorsuch leaves the court exactly where it was when Scalia was alive, except he's even more conservative, but his vote on this will come out the same way. It's still about Kennedy. If we have any chances that he's going to look at the partisanship and divisiveness that's going on in the country and everything else, even though the Supreme Court is not supposed to be political, but he's going to say we need to do something about this extreme gerrymandering that has led us to the kind of politically divisive political scenarios that, frankly, is tearing the country down. That's my hope. They could duck this case. They could duck it on a standing issue. Say that the plaintiffs don't have standing. But assuming they don't, if this is going to be decided, it's going to be because of Kennedy's vote.
We'll take some questions from the audience.
I'm with the League of Women Voters. We've focused on these issues for many years.
The microphone as well, everyone, so that people on live stream can hear your questions.
And while you're getting the mic, I just, the League of Women Voters obviously has done so much important work. And so, I commend them.
Thank you very much. The current administration and the current General Assembly's already won. They got 2012. They got 2014. They got 2016. Unless something really miraculous happens, they got 2018 election. 2020, who knows? then there's another census. So the way to keep this out of court and the way to resolve this potentially could be something that the Supreme Court decides, or more likely, it's going to be that the state has to figure out a way to form districts that is non-hyper-partisan and is not racial, and we have to have, in our view, an independent external commission to do it that will meet certain standards. I mean, this is happening all across the country, and as Juliana said, this is a concerted effort to take votes away from North Carolinians.
Absolutely, and as you know, California and, the efforts, of Eric Holder, the former Attorney General, looking at these issues, they're tremendously important. And like you, I hope that there is another way out of this. I can tell you, I mean, none of us need to be told this, that the issues with respect to the census in 2020 are going to be ugly.
Huge. Yep.
I mean, just think about, all of this immigration stuff that, this administration is pushing and fighting for. This is all about exactly what we're talking about right now. It's political power. And it's the question, frankly, of whether the white majority is going to continue to dominate in terms of power, or whether they're going to do something about the growing numbers of black and brown people in this country and preserve their supremacy. That's what this is about. Well, you know what? I wish I could say that. But with all due respect, we haven't gotten where we need. Well, I'm showing my partisanship. There are a lot of white women who voted in a way that disappointed a lot of other folks in this last election. But I know that this is supposed to be nonpartisan, but I'm not going to dance around that either.
And I think your point around that, though, is that when you look at the representatives, white women aren't reproduced amongst the leadership, right?
They're not. That's true. Yes, although I have to, again, I'm hoping that white women.
The next time they're given the opportunity. When they're given an opportunity, I mean, there's some stuff I just don't get. I'll just drop it there. I don't get it. I don't know how 63% of white women, is that the figure? Am I right about that? 53. After hearing what we all heard, voted the way they did, but they did. I mean, actually, I do think there's a theory on which I can understand why they did it, but that's not a good one either.
Yeah, hi, I'm also with the League, and I can't bear pointing out that that's actually Common Cause v. Rucho and LWV v. Rucho. But anyway, my question I think is something I've really been wrestling with and that I haven't been able to figure out why I'm wrong. So as I understand it, okay, Voting Rights Act 65 declared and that racial gerrymandering is illegal. Right? We got that. You could say it was illegal, unconstitutional before that, just on the strength of the Constitution, but nonetheless, at least from 65. So in 2011, the legislature drew a racial gerrymander. It's unquestionably a racial gerrymander. Hoffler was instructed, as we all know, it's in the depositions, it's right there in the opinion, was instructed to draw as many 51% plus one black voting age population districts as he could, and then draw the rest of the districts without, and the guy, of course, one of the guys who did the afterwards cobbled together supposed polarized voting analysis was none other than Brunel, who is going to be in charge of the census, ladies and gentlemen. So that's a real good sign, and who favors gerrymandering as being pro-voting rights in his bizarre analysis. But okay, so it was illegal for decades, and they drew an illegal racial gerrymander, and it is, at least until very recently, still in force, and they won several elections under it. So why do we think that if we get partisan gerrymandering to be declared unconstitutional, they won't just do the same thing? Draw an unconstitutional map and wait for it to be fought out in court, which takes years. What am I missing?
Well, I, for one, don't fool myself into thinking that if the Supreme Court is going to do something that I consider to be positive with respect to partisan gerrymandering, that the forces that have been behind all of this gerrymandering are going to go away. They're not. These folks do not go away. They come back again and again and again. And they shapeshift. They change what they're doing. But it will, it still will be a significant victory, I think, or maybe, it depends on how they write it and what they say. If we were to find some limitations on partisan redistricting, because what it would mean, I think, depending on how they write it, is that you wouldn't see a North Carolina, for example, or Wisconsin or some other state where the legislature ends up being totally unrepresentative of the composition of the state. It would have to, my hope would be, I shouldn't say it would have to, but my hope would be that the consequences of the election would hew closer, somewhat closer to the line of looking somewhat like the state, what the state voting population looks like. Are they going to come back and try to draw districts in a way that preserves their power? Absolutely, they're going to. There's no question. But the question is, what's in our hand to fight against these efforts to have extreme unrepresentativeness, whether it's along lines of partisanship or race, and you really can't separate those two things out right now in North Carolina or in the country. What tools do we have that we can use against these efforts to really eviscerate what remains of democracy? I say what remains because we still have Citizens United and all this other stuff out here that we need to, speak to and do something about. It's one battle, but I think it could be potentially an important one.
Let me chime in, and I think it's a question, Professor Shaw, you raised, at least in writing, about, is the Voting Rights Act old news? We need to move and think about doing other kinds of things. And this is, I think, your question. One of the things I'm thinking about the special election in Alabama, and one of the lessons from that, I think the most important lesson from the Alabama situation was, if you get your voters out, if you get more of yours out than the other side, you win. And it seems to me that this is one of the areas in which we dropped the ball, that voter mobilization, voter education, and turnout is an area in which there is room to work, and there's some power in that. And
in North Carolina legislature, they know that.
They know that.
And that's why they enacted all of these laws that made it more difficult to get voters out.
Exactly, and ID and all of this. So they want to, but this is where, right? So I grew up when my mother, I tell a story, my mother was a precinct captain and had a list. And come hell or high water, if you were on her list, you voted. And it was no question. You don't do that. It's not rocket science. Now they sit around with computers and they projecting it. No, get people in the car, take them to the polls. It's not. That's what happened in Alabama. Turnout, if you get your people to the polls. This is something that they fear. And so the efforts have been working doubly hard to limit ballot access, right? So you now have to have an ID, or you intimidate people from coming to the polls. So this is an area I think that needs some attention. Again, it doesn't cost that much. Hillary Clinton come to North Carolina or in most states and running that. If you didn't know Hillary Clinton, in like 2016, and you hadn't formed an opinion of Hillary Clinton in 2016, there was no ad that she needed to run in North Carolina would have any effect on either side of the issue. She'd be better off using that money, a lot less of it, to turn out voters in states like this and other states. So I think going back to the drawing board and the old ways of doing things and getting more of your voters to the poll is a possibility.
If it's a statewide race.
statewide race, and I think,
Statewide race.
and increasingly, see, you can look at cities, right, and I think Ted mentioned this, and then Dick mentioned that people are going to these, from the inner city, the old suburbs, and then moving farther and further out. Ain't too many more places they can get away from people of color, because the populations are growing, right, and you find the demographics are changing in those places too. So eventually, those places will be different than they are now. And it's got so many places that you can run to get away from what's happening in terms of demographics of the country. So the Republicans have been unwise to ignore what they said they would do in their autopsy and try to find ways to bring in to their party as opposed to pushing out. It's going to come, I mean, they'll regret this in the not so distant future, I think.
Hi. I have two questions. The first is, do you have examples of other states or countries that have had more inclusive voting or elections, maybe even beyond gerrymandering, but the way that the voting process is actually run? And maybe related to that, are there things like voting by mail that do encourage more voting and might have less barriers? Have you heard of practices that you recommend like that?
You know, we had one in this state, right? We had early voting, and for a period of time. And what did the legislature do? These same folks, right? They want to shorten the window. And I travel with students, and one thing I always do, we go to South Africa. We're out in the bush, and there's a little snack shop with an ATM. So I always make a point to go to the ATM in South Africa and get money out of my bank, Wells Fargo, over here in Durham, right? That's where I have the account. And I say to students, if I could do that anywhere in the world, I've done it in China, I've done it, why couldn't I vote that way? Right? Why'd I have to show up? The things we could do, and I mean, there's bank fraud, but to my knowledge, no one's ever gotten any money out of my account, in that way. And I used to be a gambler. I say used to, this is live stream. I would go to casinos in New Jersey, right? There were times I went to casino, lost all my money, go to the ATM, and the limit at that time was $300. Once I got that $300, I didn't get any more money. I mean, so there are ways, the technology exists that we could do things like vote anywhere. Would I have to be in Durham in my precinct at the church down the road to go vote? What can I put my card in from anywhere, cast my ballot?
I mean, little things. I mean, we both have daughters in high school now.
Right.
The way that they curtail the ability for high school students to be able to register, right, as a civic process, right? I mean, that should be civic education for them to learn how to fill out a voter registration card. Right.
Right.
Yeah, we have a whole set of assumptions in this country that go against democratic participation. Mm-hmm. You ask about what other countries do. And a lot of people would just gasp if they were conscious of this. In Canada, people who are incarcerated can vote. And they can in Israel. They can in South Africa. They can in other European countries. Here in this country, incarceration means not only can't you vote, but even when you get out, if it's a felony in many of the states, you can't vote. And of course, the racial effects, and also many of us believe the intent of that is or are pretty clear. I think about the fact I was driving back from New York, and there's a place outside of Washington in Maryland, and it was about 2 in the morning. So it's like, I confess that, I was going a little bit faster than I should have been going. And there's the speed limit, I think, was something like 70 or 75 in one place. But then if you take the wrong part of the highway near Washington, D.C., you probably know where I'm talking about, where it takes you into, I think, 295 or 395, all of a sudden it drops to 50. I didn't realize that I was not on 95 anymore. And so I just kept going, and I got a ticket in the mail. I'm saying the technology, they knew who I was. If they can do that, why can't we figure out a way to let people vote from home? There are a number of other things that we could do to make it easier for people to vote, but the assumption is not that we want more people to vote. the assumption, at least on the part of many, is that voting is not only a privilege, but it's a privilege that excludes certain people. And so I think there's a whole lot more that's done in other countries. There are countries with higher participation rates in terms of voter turnout. I mean, you all probably know that as well, if not better than anybody else, but not here for all kinds of reasons. Pardon me?
The number one indicator of people who are likely to vote.
If your parents voted, yeah. Well, it's interesting to hear you say that, because I know the one thing that my wife and I do when we go to vote, our kids are with us. And
that's interesting. I grew up in Colombia in South America, and we vote there on Sundays. And so for us voting, and I'm not in any way posing Colombia as an example of a great electoral system, but I remember it was a family occasion, and poll workers there, it's basically a draft. If you're a registered voter, you get picked to be a poll worker, and then you get a day off of work. And I remember it being, sometimes my mom would get picked to be a poll worker on a Sunday. My dad and my brothers and I would pile into the car, and we would wear whatever color the political party my dad was supporting. And it was there's a lot of research around party at the polls. Puerto Rico has a high voter participation rate because it turns into and souls to the polls on Sundays, which is one of the reasons why Sunday voting was taken away when they shortened the early voting period. And so, I think there's a lot. Also, online voter registration, which is available in many states. It's still not available here in North Carolina. There's many things that can be done. I think there's a lot to be learned from what's being done in other states and definitely outside of the country.
So, I have a question.
That's right.
That piggybacks on a number of observations that have been made earlier. And I'm just wondering if we have a messaging problem, right? Because when I think about Me Too and the mass mobilization around that issue, Black Lives Matter, right? And the mobilization around that issue. Voting is core. Right? The legal doctrine is very complicated, right? But at its essence is democracy, right? And of course, juxtaposed against that is power, right? But who's doing the work to try to get this issue to resonate with the American public, right? The U.S. public, in the way in which sexual assault does, or the violence of the criminal justice system, because voting affects every other avenue of power in this country, and yet I don't see students responding to this issue the way in which they respond to other issues, or the general public. And maybe if we had that mass response, not just in terms of every 4 years you have a lot of celebrities get on TV and talk about the importance of voting, but if you had investment in this issue and this right, then maybe we could use other tools other than the law, because the law is incredibly slow, as we've already discussed today. Some of these pragmatic adjustments to our system that you've just been discussing, if there were more mobilization among the public, more investment, maybe we could do some other things. Why isn't that being done? What is it about voting that's not resonating with the American population? And who's thinking about that issue?
I think one theme we've heard over and over today is that people, and I think this resonates with you, don't see themselves reflected in government and who's elected, whether it's a gerrymandered district where there's no candidate that looks like them or supports what they support. And if there is, they know there's no choice. I think for us as an organization, in 2016, it was a challenge because we're out there telling Latinos, Latinx youth, your vote counts. But really, where did it count? Nevada, Latinos counted. Colorado, Latinos counted. What do we tell all those Latinx youth in California about and this is a presidential election, right, which is supposed to be the one everyone cares about. And so I think in part a lot of this is the political system, which makes it hard to even get people to feel like their vote can count and can make a difference. And I agree with you, a lot of it might be messaging, but the system itself isn't helping us in that. And I think people are smart. If people, if Latinos aren't having someone ask them for their vote, why am I going to vote? And so if you're a 19-year-old Latino living in LA in a presidential election year, and maybe they're not facing voter ID laws, maybe they're not facing all these other issues, but do they ultimately feel like their vote is making a difference?
Yeah,
But I understand your point, right? There's structural barriers, real structural barriers that we've been talking about for the last hour and a half. There's structural barriers in the workplace. That's not stopping people from investing in Me Too. There are huge structural barriers in the criminal justice system. That's still not stopping people from talking and pushing back in their communities on this particular issue. Voting is about power, right? If you want to change power dynamics, you vote. Why is it that we don't have a way of reaching into the core of people and getting them to invest in this issue the way in which they do other issues?
So a couple of things, Professor Jones. I think about Black Lives Matter as something that gets created in the context of crisis and spectacle, which draws people into the mix. I don't think most folks see voting in that same kind of way or denial of voting rights in the same way. I think we also have to be honest about Me Too, that Me Too is largely, no matter what Me Too covers, Me Too is largely about sexual assault against privileged white women. And just the same way that missing white women show up on the 7 o'clock morning news all the time and other missing women don't, Me Too is functioning that same way. But we're of the same generation, right? And so we also grew up in a period of time where landmark court cases was part of our socialization and our educational processes, right? So that when we're sitting in 8th grade, we know what Brown is, right? We know what the Voting Rights Act is. We know what the civil, we see these landmark cases. If I look at my 19-year-old daughter, she has no reference point in her lifetime, right, or even immediately before her lifetime for those kind of critical court cases, unless we're talking about the same court cases that socialize me.
Well, I think you only learn about those court cases in school now if you take the AP classes.
Right.
And if you're not tracked in AP, then you're not getting the same kind of information.
Right, that's a great point.
And I think that also the average people don't see the way, I think average people don't see the way that our elected officials have impacts on their actual lives.
Right.
Like the Me Too movement is it's very personal. Like women and men can understand that. The Black Lives Matter movement, people of color understand that. Like you walk outside and you feel vulnerable. But I think that voting seems more abstract to people for some reason. People don't want to pay taxes. Even though taxes pay for schools, people don't want to pay taxes.
Right? Why? So that's the question that I think how do you in the way in which Black Lives Matter?
Well, there's a real disconnect, I think. And there's this discourse about elites and working class people. Somebody said a minute ago, who was it? Somebody said people are smart. Who was it who said that? You said, yeah. I'm not sure. I like to think that. I'm not sure that people are smart. Or let me put it this way. I know I can get in trouble about this. Or well-informed. As I said, how do you... and I know a lot of people are not going to like when I say this again. How do you go to the polls and vote? The majority of white women vote for somebody who said, you can get away with it. Grab them by the, I don't even want to finish it. How does that happen? What's going on with the majority of white voters that they vote for a child molester, or don't want to believe it? Now, I realize there's the evangelical piece of that and all of that, but how does that happen? And how is it that it's so different than the way the vast majority of black people are voting? What about all the black people who, in spite of the percentages that vote in a certain way, who stay home and despair and say it doesn't matter? As if, and this is the message that many voters, whether they're black, white, Latino, Asian American, that they either get or give, is that it doesn't matter, and because the choice is between, somebody who's awful and somebody who's not as awful but still bad, and so I'm not going to vote. Well, life is imperfect. Every day we make imperfect choices. We have to. It makes a difference. I mean, how is it that you see the election in 2000 and what happened, or the election in Virginia recently where it came down to one vote and you say my vote doesn't matter? Well, I don't get that. But maybe it's because I am a civil rights lawyer, law professor, snobbish, elitist, et cetera. And so there's all kinds of things that I don't begin to understand. Because to me, it doesn't seem smart. Democracy is imperfect. But the world and life is imperfect. I don't get how people don't vote. Debo talked about Vernon Damon. I've been to the cemetery with his family. I've seen that tombstone. He was absolutely right. If you don't vote, you don't count.
Can I just say my question was very simple? We're very good at diagnosing why people are not engaged, but are we as good as convincing them to be engaged? And that's where I see the challenge right now.
I think part of that, Trina, has to be a focus on local politics, right? I think that's why we're having the kind of conversation that we're having in North Carolina. I think many people, the last 10 years, were obviously invested in national politics because of the optics of it. But, if you need garbage removed on your street, you're not calling the president or your congressman, right? You're looking for someone in your city council. If your schools are bad, you're looking for somebody that's on the school board. I mean, we forget that before the legislature flipped, in North Carolina, the model of that was the Wake County schools. And so I think when we get back to really talking about local politics, where stuff dramatically impacts people, that's why the bathroom bill resonated the way it was, right? Because it's local politics and that personal piece that was just mentioned.
Yeah, and one of the things I add to this, Trina, is I think, and that's something I said earlier, is the success of the Voting Rights Act and what the consequences were, right? So here we are sitting at Mr. Duke's University. We've arrived at UNC. And I think, right, so again, and I think Mark mentioned, his children, our children, some distance away from those things. But I remember my mother voting for the first time, right, in 1968. And someone told me that there was a constitutional amendment in the 1860s, right? But, so we've arrived, right? I'm 54 years old, be 55 this year. I started first grade in Kannapolis down the street here in 1969. My class was the first one that was fully integrated. My brother, who's a year older, his first year in school was in an all-black school. And so I'd have that, I remember that, right? And the younger folks today, right, they've arrived, they haven't faced any real challenges, many types, right? We've seen wars, they haven't really seen, I still have, images of Vietnam sometimes, watching those kids on TV, watching, they haven't had those kinds of challenges. And I think the socialization has not been what we had. Now, your question, how do we get that? I think this moment, if this moment doesn't get us on the road to understanding why elections matter, I don't know what the answer is. But I think now folks will experience some things and beginning to see some things that I think people who were being woke, I think they're woke now because of things that are happening and will continue to happen with this administration. And that may jar people into getting back to where you understand why it's important to be present and to show up.
I keep asking myself this question, Trina, in relationship to voter registration. How is it that we could sell unprecedented numbers of tickets to a movie that no one has seen, that won't be released for 2 weeks, and not generate that same kind of mobilization to register people to vote?
I think we have to register?
Well, that's another question, right? That's yeah.
A good question.
That's a great question. Even though there's no guarantee that even if we registered everybody, that folks would feel compelled to vote.
Right, and the point you made earlier, Mark, too, and even my Duke students don't understand, right, that elections are a state matter, right? So people participate in national, they come out and vote every 4 years for the president. But these state and local matters is where the rubber meets the road. For the most part, for many of us, I think re-educating or educating folk on they don't understand that why they need to go and vote for the state house and state senate, county commission. And I think we need to do a better job. Even in political science, Intro to American, we don't teach this in political science. The focus is on the national and the international, and not the state and the local. So we, as educators, have not done a good job in educating American citizens about American civic life.
I feel compelled to say that, as I was thinking about what I said and my passions got the better of me, when I talked about not understanding how some people vote, but that really isn't the question. They still voted.
Right.
I don't understand how some of them vote, but that really isn't the question. Still voted, and I respect their right to exercise the ballot in spite of my maybe not understanding it. I think the problem and I want to correct myself on this score, the problem is the people who don't vote, who won't vote, who are so cynical and believe that it doesn't make a difference, and those who go out of their way to do their best to make sure that some people don't vote. And we have two kinds of people in the country with respect to voting and democracy. Those who believe that we ought to have as many people voting as we can. We ought to be, pushing voter participation, and those who believe we ought to be suppressing voter participation.
A lot of countries for years have taken the initiative to go out to their people to get them registered to vote. Unlike here, where it's all on us, those countries have a process where they go out to the people and register people. And I had a sabbatical year in Ireland once, and I went to my mailbox, and I had a European Union election ballot in it. And I was like, oh my gosh, I probably get arrested for voting this. And I inquired, I said, no, you can vote in European elections. You can't vote in Irish elections, but you can vote in European elections. And one other thing about other countries and what we might learn from, it's amazing. In this country, even Supreme Court justices say you can't take the politics out of redistricting. It's in their opinions.
Yeah.
Yet in Australia, they do a marvelous job of keeping politics out of the redistribution process, as they call it, but of setting up their state and federal election district constituencies. It's amazing. And yet we can't even, I try to understand how come they can do that and we can't. Because politics in Australia are hardball. It's not like all nice and good, but there's I go back to the comments, there's sort of a long tradition, I guess, from Westminster in England, where there's a strong dichotomy between politics and administration. And the elections are run by election commissions, and they stay pretty much above board. And the voters, even compulsory voting, voters like it. There's a small fine if you don't do it, but as I understand it, all you have to do is say, I had a headache that day, and they'll waive the fine or something. But it's just amazing, and we just can't even take step one in that direction.
I'd like to thank the panelists for coming out this evening and for engaging the audience. I'd like to thank the audience for being engaged and spending some time with us this afternoon. Thank you very much.
And let me also give a special thanks to Ms. Camille Jackson, who Camille is the communications director for DCORE, and she pulled all this together on very short notice. So thank you, Camille, for the help and assistance. Thank you very much.
Thank you.
Good night. You come to dinner? Yeah. Think you go join us for dinner?
No.
You gonna go back to work?
I know the answer to that.